All throughout the state, everybody's talking about this Pena-Flores case, and it's like bzz, bzz, bzz. I hear everybody. And they know it's an important case. They know it's a landmark case, but they're just not quite sure why it's an important case. It's a landmark case. Well, today we're going to find out why. And you guys are going to know everything there is to know about this before you leave today. Now, by way of introduction, here's how we have our CLE structure today. First of all, you should understand that since we have a member of the judiciary on our panel, I thank him very much for being here today. Thank you, Your Honor. We'll be presenting an objective presentation today. There's no advocacy here. This is straight black letter law you're going to be getting, okay? You can take it back and use it however you have to, because we have defense counsel here, we have prosecutors, we have police, we've got a whole spectrum of society here. So use it however you have to in your professional endeavors. Basically what we're going to do is the following. We're going to talk about, first of all, introductory stuff dealing with the automobile exception to the warrant requirement, because that's what 90% of the Pena-Flores case is about. And we'll talk about the cases dealing with the automobile exception under New Jersey law, and then discuss the cases leading up. Basically, we have in the notes called prelude to the Pena-Flores case. Then we'll discuss the Pena-Flores case in great detail, not only in terms of its holding, and the things that it talks about itself, but also the impact it has immediately on other exceptions to the warrant requirement. We'll also discuss the administrative and procedural aspects of the case, many of which will have to be determined by a task force, which is being put together at this point by the Supreme Court, which will basically kind of decide all these collateral issues we have to talk about. All right? Automobile exception. I want to just give a little bit of background before we get into some of the case law about the automobile exception to the warrant requirement. This is an exception that was created by the United States Supreme Court back in 1925. And keep in mind that in that era we're dealing with communications that we certainly, people there never could have dreamed what we'd have today in 2009, as opposed to what things were like in 1925. And the court recognized that when the police make a motor vehicle stop out in the middle of nowhere on the highway, it's just impractical for them to be able to get a warrant, even after they've established that there's probable cause to believe that there might be some type of evidence or fruits or instrumentalities of crime hidden inside of a motor vehicle. So for those reasons, the court determined in the Carroll case that because of the exigencies of the situation and the impracticality of getting a warrant, a police officer who has probable cause to believe that there is either evidence or fruits or instrumentalities of crime inside of a motor vehicle can conduct a search of the vehicle there on the spot in order to recover that evidence. There's lots of justifications for it. The main one that the court was concerned with in 1925 was the inherent mobility of the car. I mean, if the police had to wait around to get a warrant for 3 or 4 hours, given the communications at the time, there's a possibility that either the defendant or a confederate or the defendant could just take the car and drive off, and there goes your evidence and there goes your case. Now, following the publication of the Carroll case, which created this exception to the warrant requirement, the court came up with additional justifications to support this exception to the warrant requirement. So we have the Chambers versus Maroney case, and again, they talk about the inherent mobility of automobiles, which creates exigent or emergent circumstances, making it impractical to obtain a warrant. Makes sense. The California versus Carney case from 1985, more recent, talking about the reduced expectation of privacy that you have in motor vehicles and the need for regulation of motor vehicles. You all know that you have expectations of privacy that are protected by the Fourth Amendment. In fact, if the search takes place in an area where you don't have an expectation of privacy, the Fourth Amendment really wouldn't apply. Take, for example, the quintessential place where you have the greatest expectation of privacy is going to be in your own home. But you have lesser expectations of privacy in different areas. One of them is your car. Yes, you have an expectation of privacy. It's reduced because you're out in public. You have windows in your car. People can see into your car, things of that nature. So all those things militated in favor of this exception based upon the reduced expectation of privacy. And also because driving a car is really kind of a pervasively regulated activity, one that you're going to talk about in the commercial context, I think, right?
Whatever you say, Bob.
All right, good. Now, the most recent pronouncement by the United States Supreme Court came in the case of Pennsylvania versus LeBron. This is a decision written by the Chief Justice. And it changed the law federally to make searches of motor vehicles under the automobile exception much easier for police. The holding of that case was the following. If the car is readily mobile and probable cause exists to believe it contains contraband, the Fourth Amendment permits the police to search the vehicle without more, meaning that all you require federally is probable cause, all right? Now, I have to tell you, that is not the law in New Jersey. keep in mind that when we talk about these exceptions today, that under our system of federalism, individual states are permitted to provide more protection under their own state constitutions than you would get under the United States Constitution. So you really have to think about it as the Fourth Amendment being a floor as opposed to a ceiling. In other words, the Fourth Amendment describes the minimum amount of protection you can get in our country, and individual states are free under their own state constitutions to provide you with additional protections, all right? So the LeBron case is perfectly fine in terms of federal law, but New Jersey's taken a different approach, and the Cook case is the main case dealing with that. Judge McGinty, can you talk about the Cook case?
I can. And that's exactly what happened in Cook. New Jersey Supreme Court took the position that the New Jersey Constitution afforded greater protection for the citizens. Let me tell you the facts of the case. A reliable confidential informant reported that the defendant was selling drugs at a housing complex known for drug trafficking. The defendant was storing the drugs in a Ford Escort. The Jersey City Police conducted a surveillance and saw the defendant in a parking lot working on a Ford Escort. The officer saw a man give this person some money, and the defendant then walked to the nearby Hyundai, removed the plastic bag, and then gave it to the person that gave him the money. Later, the officer saw the defendant hand a white object from the Hyundai to another man who remained on the scene. The defendant also removed the plastic bag from the Hyundai and put it under the passenger seat in the Ford Escort. The defendant then drove away in the Hyundai with a person named Brian Miles, who was known to the police from prior arrests. Backup police officers stopped the Hyundai and Mr. Miles and told Mr. Cook that he was under arrest because there was an outstanding warrant. And as part of the arrest, they searched him and they found a set of keys for the Escort. They asked him if he owned the Escort or knew anything about it, and he denied. No, these keys in my pocket, I have no idea how they got there. I don't know anything about the Escort. Very credible man. They then went back to the scene where the Escort was, used the keys, and they searched the Escort, even though he was still denying that he had any connection to it. The surveillance officer did the search, and he found drugs. The defendant filed a motion to suppress, which was granted at the trial level, and it was appealed by the state to the appellate division, which also affirmed the granting of the motion to suppress. The state appealed to the Supreme Court, and the issue was, did a search require both probable cause and exigency, different than it is in the federal system? And the decision was yes, both are still required in New Jersey. But the trial court did grant, but the trial court did reverse the Supreme Court reversed the trial court's decision. The Supreme Court said that the United States Supreme Court has essentially disposed of the additional requirement of exigency, making virtually all warrantless searches of vehicles valid under the automobile exception, so long as it's supported by a probable cause finding. It was based on the inherent mobility of vehicles, which created in and of itself the exigent circumstances. New Jersey Supreme Court disagreed with that, once again interpreting the New Jersey Constitution as affording greater protection for the citizens of the state of New Jersey. The New Jersey Supreme Court ruled that the justification for a warrantless search turns on whether it's impracticable to obtain a warrant. And the Jersey court said that without a requirement of exigent circumstances, a car parked in a driveway of vacationing people could be searched without the benefit of a warrant, so long as the police had a probable cause. The lessened expectation of privacy is only one factor to be considered with others in determining exigency. Despite the ruling against the state in terms of whether exigency was still a requirement, the court found that in this case there was exigency. They found that the possibility of other persons having keys to the Escort and therefore having access to it